Okay, cool. So let's just jump in here a little bit. So again, we're going to kind of start with the this paperwork is there for a reason. Again, right? It's a repeat on that.
Yeah.
So it's all going to be this stacking sheet in .loop. Use the system, guys. It's all in there. The purchase agreement. There's a couple. The buyer's advisory form, and honestly, that may even be signed up front when you first meet a buyer. Right? When you do, so when we teach you how to go through the paperwork, and we're not really talking, we're talking about the risk side of not the whole presentation side of how you do this. But those are the things you tell up front to frame yourself before you write this. But this is very important that buyer's advisory form is in there. We're going to talk a little bit more about it, but it covers all the things to avoid being sued over. Every one of those things, somewhere, some way, someone got sued. Now, the good news, they weren't key agents because we used the form. But we'll talk a little bit more about that. But having that in there, the broker compensation agreement, guys. Remember, this is a new world we live in.
How you get paid?
You have to get paid, right? You have to have that agreement. How you get paid is addressed in transparency. All the required agency documents, right? We just can't tell you. Again, the residential property disclosure form, if it's applicable, the lead-based paint that they were signed, and have them in there. The home warranty, whether it's accepted or declined, or part of the process. And again, the affiliate business arrangement agreement, even if they're not using our mortgage company, title company, it still has to be signed. And all the other addendums. Now, this is kind of a big thing. We say all other applicable addendums. And I think one of the things when it comes to paperwork, and we'll speak about this further, is that we don't have a big blank addendum in there for you to write a lot of language. The idea is if you're ever with a situation that needs further clarification, there probably is an addendum. Before I did this class, I was just counting on the addendums. I stopped counting at 100.
Yeah.
And there's for different circumstances, anything from vacant land to, we'll talk about this a little bit further here, about vacant land, foreclosure, short sales, any kind of situation, rent back from the seller, any kind of lease purchase, any kind of situation that's a different. There's an addendum in there to help you move through that. You can find them in a knowledge base. You can go through there. But that paperwork is for you not to dream up paperwork and act as an attorney, but to actually use the proper paperwork. And that's what they're going to look for in those situations.
You know, at the risk of jumping ahead, I can tell you that as we go through this class, things go ding, ding, ding. And one of them is where agents get in trouble is with verbal agreements regarding inspection repairs and extensions of inspection periods and that sort of thing. And do never tell the listing agent or the selling agent, oh yeah, well, I know the listing repair period expired on Monday, but we want to extend it to Thursday. Yeah, that's fine. I've talked to the seller. Everything's cool. But not necessarily, because on Tuesday you might get another offer in that's $10,000 higher that you have to disclose to your seller. And all of a sudden, what you told somebody isn't true. Don't make decisions for other people. Make sure that, and when they make a decision, make sure that that is memorialized in writing between the two parties. Never say, oh, that'll be fine. I'll talk to my seller. Don't worry about it, etc.
It's fine until it isn't, right?
Yeah, it's fine until it isn't. And a huge percentage of the times where we get sideways in a transaction is because there's a discrepancy between what was verbally agreed to and what's in writing. So when somebody says, I want an extension or I want to handle this repair or whatever, make sure you got it down somewhere. Okay, here we go. So we're going to go into some of the subtleties now. The deadlines.
Yeah, you talked about deadlines. If they're not met, basically it's a counteroffer, right? It's not. They can't just sign it. It's not accepted if they went beyond the deadlines. Should deadlines be in there or not? Yes, you could have a live contract out there without deadlines being in there. Well, if it's not, someone could sign it 5 days later. If you didn't either would revoke it, or it didn't expire, and then all of a sudden your purchaser now has two houses, which could be somewhat. So make sure you take the contract class, understand it. It's really important. The other thing is chattels of personal property. I always just put the example of above ground pool. Is it chattel or personal property?
Birdhouses.
Yeah, birdhouses. Hot tubs.
Hot
Right?
tubs.
My answer is
Yeah.
it depends, right?
Yeah. Well, who knows? When in doubt, put it in the contract.
There you go.
Yeah.
Simple as that.
Yeah.
But what,
Plain English.
Yeah, just put it in the contract, whether it stays or not. When in doubt, put it in there. Do you want to win a $10,000 lawsuit to determine the $5,000 hot tub should have stayed or didn't stay?
Yeah.
You don't want to be right. You're trying to avoid issues. Put it in the contract. Just put it in the contract, whether it stays or whether it goes. All right. If the buyer wants it, put it in.
Any question, anything not permanently fixed to the property.
Yeah. Right now we're seeing it with, and this is questions right now, just as long as we're hitting a personal in chattels, is sheds.
Yeah.
People are these buy to own sheds.
Yeah.
Water systems, do they stay or not? Some contracts are some of the board contracts we use very good at addressing them, others aren't. When in doubt, make sure it's clarified whether it stays.
Propane tanks, stuff like that. Yeah, just write it out, guys. Write it out.
Alarm systems is one big one.
Yeah.
Inspection rights. Make it subject to the buyer's approval if that's what it is. Make sure the language is very clarified. They understand what the process is. They've met their times and deadlines, and what happens if they don't meet those deadlines. Title work. Generally, the seller pays. They examine the record of title. There is generally a seller will pay for the title work for that part, but title insurance, typically the buyer will pay for it. Now, this is different in market to market, but the one thing to remember is title insurance, they're always one-time fees. One-time fee. It's not a monthly fee or anything else. It protects you the entire time you own a house. The difference with title insurance is for a small increase in cost for the policy, it protects fraud and mistakes. And guys, that's where the real issues are going to be.
Get title insurance on every deal you do. I mean, no matter what. I mean, you don't know what you're looking at. You don't know what you can't see.
Unrecorded issues.
Yeah, there are millions of dollars in claims are paid out every year from title insurance.
And that's one of the things that's on the buyer's disclosure.
Yeah.
Right in our purchaser disclosure advisory, it says that exact line.
Get title insurance.
Yeah.
Good.
Yeah.
Okay.
What are some of the other issues that you see that you'd want to point out in this class?
Well, I think I would say these are things that have given us problems in the past, and probably the most prevalent one would be earnest money.
Yeah, I agree.
And being deposited in a timely manner as soon as possible is what the law says, and typically that's 1 to 2 days. So when you get earnest money, get it in the account. If you have let's say that Monday you have an accepted offer, the money's supposed to be in shortly. 4 or 5 days later, that money's still not in the account. The buyer reconsiders their position. They call up and say, well, we want out. And the seller's attorney calls us. The first thing they're going to say to us is, where's the earnest money? If it's sitting in your wallet or your purse, there's a problem, okay? And it's a big problem because at that point in time, that seller's attorney can allege that you were derelict in your duties and you have a problem, okay? So don't do it. Get it in. It's real simple. You know, use it. Something I do, this is something I would do every time, is if I'm driving and I'm like, oh, I got to do that earnest money, text yourself. Send yourself a text message. You can do it through Siri. Get the earnest money in there tomorrow morning. And then tomorrow morning when you're reviewing your day, that'll be staring you in the face. Get it done. Okay?
You know, the other thing is if the buyer's supposed to turn in the earnest money or turn it directly to the title company, you have to follow up to make sure it happened. And if something happens, the check bounces, they didn't do it, that is something actually, if it happens, get with your manager, but really is something as buyer's agent we need to disclose to sellers.
Wait until after, put language in your contracts that says that the earnest money is to be deposited after the inspection issues have been resolved. And that way you can avoid the problem of having these earnest money checks floating around and stuff. It's a great idea. Fraud advisory, make sure that form is signed. We had an agent who had an $80,000 issue because they notified a seller. Actually, they made a mistake and directed someone regarding funds. Wire fraud is real. It's a $1 billion industry. Yep. Here's what you do to avoid problems with it. Make sure that the seller and the buyer understand they're never to rely upon emails which can be spoofed to basically imitate a title company and call the title company for verification. The form is very explicit about what to do and how to do it. Don't show down payments from the buyer to the seller, because that can be used as a negotiating disadvantage to your purchaser. There have been issues regarding this sort of thing, allegations that should have been held in confidence. And always remove excluded items prior to showing a house. Memories are flowing back through my head again about chandeliers and things that people wanted to take with them but didn't. Exclude from the contract. So if something needs to be excluded, try to remove it prior to showings.
Yeah, I'll tell you, one of the things I've always seen too is closing dates. Just be realistic.
Yeah.
And and honestly, if it's a lender, sit down with the lender. Talk to the lender. What dates make sense?
Yeah.
Right. Remember, around the holidays, it will extend it. Just think about how many days we lose that possession date and time. Careful if it's at closing, that people actually can get out of the property part and they understand that the property now will be vacant. Any kind of specific disclosures, make sure they're in writing. If a seller has said, "Oh, by the way, it floods into this," or "I can't," any kind of specific must be in writing for the buyer and the seller.
When in doubt, disclose and record.
Attorneys review, both purchasers and sellers have the right to have their attorney review it, and make sure, if that's important to them, that it's in there. Make sure they understand they have that right and put in there. Deed preparation is typically a seller's expense. We'll have, if you do a good net sheet, people will understand that, what that cost looks like. Maintaining the properties until closing. Oh my goodness. If it's in the summer, they need to water the grass. If the grass was green, look great, they have to keep it that way till it transfers, right?
Tell them not to have a party because they're leaving, or whatever. They're responsible for maintaining the property in as good a condition or better as when they saw it.
Correct.
That's what the law says.
Yep, that's what the law says.
So explain that to them. If there's a fire or something in the meantime, the contract says that they can go ahead and negotiate that out if they want, or the buyer can void the contract if there's significant damage. Willful default and termination. If a buyer just decides to walk, or a seller in particular decides to walk, the extent of the liability is not the return of earnest money to a buyer who backs out. And a lot of attorneys will tell people that, a lot of agents will tell their clients that, and it's simply not true. When somebody willfully defaults and walks away from a transaction, a purchaser, their actual legal liability is any and all damages that a seller incurs as a result of their non-performance. So be sure to say that. Don't say that it's the earnest money and earnest money only.
It's funny because I agree with you. There's that common misperception, even among some agents, that, well, what's the worst thing they do is take my earnest money, and that's not even close.
That's not even close.
I would say contracts have consequences. You need to talk to those with your attorney.
Yeah, you need to say, if somebody decides that they want to back out, say, well, I understand that that's your position. But before you make a final decision on that, this used to be my little speech, before you make a final decision on that, that decision may have legal unintended consequences, possibly legal consequences. You need to speak with your attorney before you make a final decision on this. And if they're still adamant that they need to do that, you need to send an email to them that says exactly the same thing.
Correct.
To protect them, because it does have legal consequences. And they need to get in front. Usually an attorney, any sensible attorney, is going to sit down with them and say, hey, just because you didn't close on this deal doesn't mean you didn't buy this house. You bought this house. Closing is an after consequence. And if the sellers come after you, you might want to consider
potential damages.
But there's potential damages involved in this. And usually they'll go ahead and proceed, but don't argue with them. Tell them that there may be, whatever you decide is fine with me, but before you make a final decision, I would encourage you to reach out to an attorney and at least review your
My other piece of advice is please get your manager involved.
Yeah.
If it's a seller that doesn't want to move forward, or buyer, get your manager involved.
Yeah.
That's the key. Doesn't happen very often, but when it does, That's what your managers are for. Dennis, one of my favorite things, I previewed you were going to tell them about this. How do you get zero deductible?
Well, this is so exciting.
So we have errors in mission insurance.
So this is
protects you if you make a mistake, some kind of error, some kind of mission. But how do you get zero deductible where it doesn't cost you anything?
Well, you have to use a board-approved contract. You have to have a home warranty accepted or declined. Accepted or declined. You have to have an inspection on the property, and you have to have a property disclosure form signed by all parties. Now, this is the cool part. If you do all that, you automatically get zero deductible. And if you follow the bouncing ball and do this business the way we ask you to, even if the property disclosure form says, I never lived there and I don't know anything about the property, these are the component parts that you need. At that point in time, the normal deductible for a lawsuit in the real estate business is $5,000. If you do this the way we ask you to, you should never have occasion to pay $1 of damages to anybody for any reason. So if you make a mistake, every agent involved in this company should always be in a zero deductible situation. Yeah. Always.
You know, it's a shame because we've seen circumstances where it hasn't been, and they just scratch your head and say, I really didn't understand. They could have just declined it and it would have been covered.
Yep.
The other thing is when you think about this, when you're using a board contract, that there's not crazy language in a contract. You're using a well-written contract. If you're using a warranty, that really warranties cover about 60% of all problems of houses anyways.
Yeah.
And then if there's an inspection, they would pick up those other things. And then if there's a disclosure that the seller disclosed or not, then generally the reason that the warranty companies pay part of this deductible, we pay the balance of it. That's how it goes to zero.
Yeah.
But the reality is if you do these things, your liability drops so dramatically. That's why this is part of it.
And we're able to offer this product, which is fantastic. I believe it's one of the most important things about working here, truthfully, okay, is the zero deductible environment that our agents always work in. Moving on, these are some general ideas and things that we think are really important to you.
Basically, through experience of these things have happened. Yeah. That's why they're out here. We just type up what happened.
Here's what you
disclosure.
Yeah. Here's what you. Yeah. This is like real estate nightmares revisited for us. But here's what you don't want to say to a client. Don't worry about. We have a deal. The listing agent called me back and said, if their sellers are fine with it, we have a deal. So it's 6:00 at night, right? 9:00 tomorrow morning, that listing agent gets 2 other offers on the property. You don't have a deal. But you told your buyers you do. Now you have a problem. Okay, here's what you say instead. We have an agreement in principle. Nothing has been signed, but we need to get something in front of them as soon as possible to make sure that we can consummate or finish this deal. We do not have a deal at this point. If you have somebody who's really problematic, I would say we don't have a deal at this time. We have an understanding, okay? And we need to get it done as soon as possible. So, who sues us? Buyers and tenants primarily. When is an offer accepted? It's accepted when both sides of the transaction have a completely and fully executed agreement. Use dot loop to get that delivery going quickly. As soon as you have it in the listing agent's hands, it's been signed by all parties, you're good to go. Try to get that done as soon as possible. Most dangerous thing you can say is, I don't need an attorney. Okay?
You don't need that.
Just don't do it.
I take care of everything.
Oh, you don't need an attorney. Don't worry about that. I'll take care of everything. Okay? Don't do that. Okay?
Well, now you're held to the status of an attorney.
Thank you.
No longer like a real estate agent. Now they're going to hold you to a whole different standard. And it's practicing law without a license. It's a bad idea.
Easiest thing to forget, the last set of initials. Biggest problem for the state, as I mentioned, is earnest money.
Just clarity. We just need clarity.
We just need clarity on all of these issues. Percentage of fair housing complaints is 79% tenants. There are allegations that are real for fair housing. If you have any kind of allegation regarding fair housing or discriminatory practice, you need to get on the phone immediately with us, okay? Yep. We have a great relationship with the Fair Housing Center, the National Housing Alliance, etc. We can help you with any kind of problems that you have.